And good afternoon, everyone. My name is Patricia, and I work for the City of Mountain View's Rent Stabilization Program. This afternoon, we have a presentation mostly geared toward property owners, new property owners, and realtors. And this is going to be the very basics of what you really need to know as a new property owner in the City of Mountain View, the rent stabilization laws that affect you, and how that impacts the price of rent, the price of rent increases, and your ability to remove tenants from units. We're going to go over a lot this afternoon, and we have just under an hour to do that. So please feel free to use the chat function or the Q&A function to ask me questions. I prefer the Q&A function, so if you can use that, that would be best. And I will take breaks occasionally and allow for me to answer the questions in the Q&A, or if you raise your hand to allow me to speak with you and have me answer your questions out loud and in real time. So we're going to go ahead and get started. Again, my name is Patricia, and today is May 16th, and we're going to go over some basic rights and responsibilities of landlords of properties in the City of Mountain View. So before I get started, I just want to remind everyone that as city staff, I'm not able to provide legal advice or assistance, but I can provide you with information about the law. So if at any point you ask a question where it might be lending toward what I would consider legal advice, I will make a mention of it and steer us back toward information that I can actually provide. Okay, so how did we get here? What's the background? We have rent control in Mountain View because of a voter-approved measure called the CSFRA, which stabilizes the community by reducing housing turnover in certain rental units in three main ways. So CSFRA is short for Community Stabilization and Fair Rent Act. We also have the Mobile Home Rent Stabilization Ordinance. However, those properties haven't turned over recently, so I don't think I'm talking to any new property owners of mobile home parks. So I'm going to focus on the CSFRA today. Most of this is also applicable to mobile homes, but it gets a little bit more complicated with mobile homes because of a state law called the Mobile Home Residency Law. But again, I don't think we have any mobile home owners here today, so I'm going to focus on the CSFRA. If you are a mobile home owner and you want specific information about mobile homes, you can always reach out to me and I can help you offline. So three main ways that the CSFRA impacts tenant housing in Mountain View. The first is that it stabilizes rents. So it keeps rent increases under a certain amount to make sure that rent increases are not being given so frequently or at such high amounts that tenants are not able to prepare and absorb them. Two, it provides eviction protections. There are only 9 reasons to evict tenants in the City of Mountain View, and they are very specific. They're called just cause eviction protections, and we're going to go over them. And then the third is to ensure a fair rate of return on your investment as property owners. We're going to go into that very high level today, but those are the 3 things, the 3 main goals of the CSFRA. So the first question that you're probably asking yourself is, am I covered? Does this law affect me? And the answer for that is that most apartment buildings, most multifamily homes with 3 or more units on the property are covered by the CSFRA. And in general, units provided or subsidized by the government are not covered. Fully covered, there are 2 types of coverage. One is fully covered and one is partially covered. This is due to a state law called Costa-Hawkins. Fully covered units receive both eviction protections and rent stabilization. And those are units built before 1995. Units built after 1995, but before the end of 2016, when our law went into effect, are only covered by eviction protections. And if the units were built after December 23rd, 2016, then they are not covered by the fully covered portion of the law or the partially covered portion of the law. They're not covered at all. However, they might be covered by the state law, AB 1482, but that's not part of our local law. So right now, just keep in mind, we are only talking about the CSFRA. So we have coverage exemptions. This goes into a little bit more detail on what this means and what this looks like. For the most part, you can see the fully exempt, what classifies as a fully exempt unit. Single family homes, however, this is not always the case. If there are 3 or more units on a parcel, then the single family home is covered by the CSFRA. And if it's built before 1995, full protections, including rent stabilization protections, apply to that single family home. Condominiums and companion units are not covered, and duplexes are not covered. So if you have a property where there's a duplex and a single family home, the single family home is covered, but the duplex is not. Units in hotels, motels, et cetera, that are rented out for less than 30 days are not covered by the law. Units in hospitals and dormitories, medical care facilities are not covered. And like I said, in general, government or subsidized rental units are covered. BMR, below market rate units, are covered. And if you have a tenant who receives an affordable housing voucher for their own household, that tenant is still covered by the CSFRA. We have a rental registry that you have to go into and register your property at. It is mandatory. If you don't register your property with us, you are in violation of the law and you cannot increase the rent on any unit. If you increase the rent while out of compliance with the law, those rent increases are unlawful and have to be refunded for you to be right back into compliance. So if you're concerned that you haven't registered, go ahead and reach out to us and we will follow up with you. You also have to submit required notices, including termination notices, banked rent increase notices, and additional occupant notices. And you have to pay your rental housing fee every year. So registration and rental housing fees have to be done every year. The due date is January 31st. If you don't do either of those things by January 31st, you're in violation of the CSFRA and our regulations. And that means that you're out of substantial compliance with the law. If you're out of substantial compliance with the law, you're not able to increase rent lawfully. And tenants can file a petition with us for that. Okay. So there are some other things that you should know before we get into what coverage looks like. So we have our rental registry, and I just mentioned the rental housing fee. The rental housing fee is a fee that as property owners, you pay every year per unit. And I apologize, I thought that I was in a different slide deck here. Your rental housing fee for the current cycle that we're in, we're missing a few here, is $108 per unit. And so I need to update this slide and I apologize for that. The payment of this fee, this $108 per unit fee, was due January 31st of 2024. So before we get into our landlord rights, federal, state, and local laws, I see that we have 2 questions and I'm going to go ahead and pull them up and answer them. This asking, are single family homes built before 1995 with only 1 unit CSFRA covered? So no, if there are 3 or more units on the parcel, they're covered. If there is only 1 unit on the parcel, they are not covered. They might be covered by state law AB 1482, which provides rent stabilization and eviction protections for most rental units in the state, but you're going to want to look into that on your own. Alrighty. So the next question is, are the fees being sent by the city on a regular basis? We send the invoices at the beginning of January every year to the properties. And you should receive them, within the first week of January. So yes, that they're being sent annually as required. And then this last question, if the property was fully renovated after 2010, would this be fully covered? Yes, it would still be fully covered. those units have not been withdrawn from the market. They're still being rented. The renovations don't remove the property from coverage. Okay, so we're going to jump into your rights. What are you required to do? What are your responsibilities under these different types of laws? So we have the federal law that is applicable to property owners, state law, and local law. You'll see here we have all of them for your reference. As a property owner, you're going to want to look into this. This is really helpful. All of these are really, 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 really important for you to know, to understand, and to follow. The California Civil Codes, especially 1953 and 1954, are very explicit about what you can and can't do with entering homes. And then there's a lot of important things to know about fair housing, discrimination, civil rights, and how you as a property owner are impacted by those laws. You as a landlord are impacted by those laws, and how your tenants are protected by those laws are really important. And then, obviously we have the state laws, and then local laws, the Community Stabilization and Fair Rent Act, which is most of what we're going to talk about today. Tenant Relocation Assistance Ordinance, or the TRAO, and then the City Code Chapter 25. So that's our inspections and what you need to do to be in compliance with building codes. So your rights during tenancy, before tenancy, and post-tenancy, you have the right pre-tenancy to request a tenant screening, to have a rental agreement, house rules and disclosures, and to collect security deposits. You also will want to consider how to accommodate reasonable accommodation requests and ensure you're doing that correctly under the law. During tenancy, you have a right to collect rent payment and rent increases as allowed under whatever law is applicable to you, to maintain the habitability and quiet enjoyment of your tenants, and to make and accept reasonable accommodation and modification requests as required by the law. If you ever have questions about that, you can contact Project Sentinel, and I'll make sure that their contact information is provided so that you can get more information on reasonable accommodations and how that impacts you as a property owner. During the termination of a tenancy, you have the right to file eviction and termination notices, as long as they are the ones that are allowed under the just cause protections of the CSFRA. You have a right to provide noticing, and again, ensure that you're in compliance with reasonable accommodations. And then post-tenancy, you have rights with your security deposit, how you reimburse it to the tenant, what you're allowed to take from it. And then there's also the requirement for tenant relocation assistance, and we'll talk about that in a little later. So pre-tenancy, what does this look like? Screening. You have the ability to screen tenants on creditworthiness, rental history, past evictions, and income. However, it has to be non-discriminatory. You can ask questions like the names and ages of occupants, phone numbers, prior addresses, copy of pay stub, bank account numbers, etc. But you cannot request information on immigration status, familial status, ethnicity, medical information, or request copies of bank statements. And keep in mind, this is what fair housing discrimination would look like. A discrimination in practices of recruiting tenants and having tenants sign leases that are based on tenants' race or color, on their religion, their national origin, what language they speak, their immigration status, their familial and marital status, their gender identity, their sexual orientation, or their sex, their disability, or their age, the sources of income that they have, or if it's arbitrary discrimination. If these things are, you can have fair housing actually come to your apartment, and lawsuits can be filed against housing providers that are found to be in violation of these federal laws. So this is really important. And again, Project Sentinel provides great services about this to help you make sure that you're not in violation of these things. Rental agreements. So what can you put in a lease? You can make them month to month or fixed lease terms. You have your name, the owner of the agent, who, where, what, when to pay, rent amounts, the amount of utilities, security deposits, if you're allowed to sublease, fees, disclosures, and house rules. These have to be in compliance with the CSFRA and the definition of rent. Right now, we're going through a whole process about rent and utilities to incorporate utilities into rent. And we'll only talk about that very briefly today. We have an entire presentation coming up on June 18th to continue to catch people up on those requirements. And we will have multiples of those coming up in the next few months. So I'm not going to focus very much on it today at all, but I just want to remind you, utilities should be included in rent. Just remember that no matter what, tenants cannot waive their rights through the signing of a lease. So even if you put in there something that violates the CSFRA or state or federal law, that doesn't matter. Tenants can't waive their rights. If something in the lease violates their rights, that provision of the lease is not valid. So what to keep in mind during tenancy? During tenancy, we're going to go over rent payments and increases, habitability, the right to enter, and reasonable accommodations. So what is included in rent? Base rent includes the initial rent of the physical space. Any parking fees, pet fees, utilities are included that are not provided directly to the service provider or submetered. Storage and housing services. You can increase through the rent through the annual general adjustment, which we'll talk about briefly, petitions, which we'll talk about as well, and banked or bankable increases. Deposits are not included as rent. Deposits are not included as rent, and they cannot be increased during tenancy. What kind of deposits are there? Security deposits, pet deposits, other types of deposits might be applicable. So what is base rent? There's a very specific definition of this. If the tenancy started on or before October 19th of 2015, the base rent is the rent that was in effect on October 19th of 2015. If the tenancy started after October 19th of 2015, the base rent is the initial rent at the start of tenancy. And these are the allowed rent increases that have gone into effect in the past few years. We're only showing some of them, not all of them, since the start of the CSFRA, because that's starting to get to be quite a list. But since 2020, this has been the allowed rent increases. And I have the updated one here. So starting on September 1st of 2024, you as a property owner can increase the rent by 2.4% for the period between September 1st, 2024 and August 31st, 2025. And I want to make note that only one rent increase can be given every 12 months. So after the initial term of tenancy, you can only raise the rent every 12 months by this annual general adjustment. However, if you don't use your annual general adjustment, it doesn't ever go away. It kind of goes into what we call a bank, and it becomes a banked or bankable increase. And you can combine the AGA with a banked increase for a total of up to 10%. So if you only have the AGA to give, you can't give an increase above 2.4% coming up, or right now above 5%. There's a typo here. This shouldn't say 3.5%. It should say 5%. My apologies. So it can't be above 5% right now. If you give the increase after September 1st, it can't be above 2.4%. But if you don't use your AGA in a given year, again, it goes into this bank, and you can give a total increase, including the current AGA, of up to 10% if you have that many banked increases available to you. So when you are going to notice a rent increase, you have to give 30 days notice. You can only give one rent increase per month. And if you do a banked increase, you have to give at least 30 days written notice, and you have to provide us, the Rent Stabilization Division, with a copy of that online through that mvrent.mountainview.gov portal that I mentioned way back here. I just want to show it to you again. So this here, if you do a banked increase, you have to go in and submit, as you can see here, a banked rent increase notice with us. And there is specific language that you have to use when giving a banked rent increase. We have a very specific form that helps you with this. So if you're thinking of giving a banked increase, just reach out to us or go to our website and you can find the form there. And it gives the very detailed and specific information that the tenant is required to be given when you give a banked rent increase. If you don't give that language to them when you give a banked increase, then it makes the banked increase invalid and you'll have to refund money and renotice the increase, and it makes it a lot harder. So just make sure that you're using the form with the information on the back of it. So when can rent be raised to market? Market rent is an important thing in this industry that we're all talking about right now. And it becomes applicable when a tenant moves out. So when a tenant moves out, we go through something called vacancy decontrol. And that means that you as the property owner can reset the rent for that unit to whatever you think the market can bear. Whatever you think is right for that unit, that empty vacant unit that was vacated because a tenant moved out or because you lawfully evicted them, that rent can be reset to whatever the market rate is. And a new tenancy then starts. You can also consider increasing the rent above the AGA or to market if all of the original tenants on a lease have moved out and only ones that are like the holdover tenants that aren't on the original release are still in the unit. That second one gets a little bit complicated, so you'd want to reach out to us and we can help walk you through it. But the basic, most common one is the tenant has moved out and now you can reset the rent to whatever you feel the market can bear. Who's allowed to live in the unit? So eligible family members, and I'm not going to read all of these details, but this is the gist of who can move in and what it looks like, what you have to do for it. Replacement roommates, which have a specific definition. If you have a roommate and that roommate moves out, you're allowed to have a roommate that moves in. And you can perform as a landlord a tenant screening for that. And then subletting and adding roommates when the lease allows. One thing to keep in mind for rent payments is that there is a state law that says that you as the property owner must accept third-party payment of rent, as long as that third party provides signed acknowledgement that they are not currently a tenant, and that the acceptance of rent payment does not create a new tenancy with a third party. So just make sure that you know that third party payment of rent must be allowed. So for instance, if you have a tenant who is requesting rent relief or rental assistance, you as the property owner have to allow for that payment of rent from that provider. Okay, before we move on to petitions, I'm going to go ahead and take a look at our Q&A. Are Section 8 units considered government subsidized? So Mike, this is a little bit of a complicated question. Section 8, if the whole apartment complex is covered by affordable housing, that could technically be considered not covered. We don't see that a lot. If you have a voucher holder and that voucher holding tenant for Section 8 or for affordable housing vouchers that aren't Section 8, that voucher goes with a specific tenant, those units are covered by the law. So those tenants are covered. They receive full protections from evictions and from rent increases. The rent can only be increased as allowed under the law. Hopefully that answers your question. If it doesn't, please reach out to me. A tenant does not have to give bank statements to you. That can be considered a fair housing violation. How can a landlord verify a potential tenant's ability to pay rent if no copies for bank statements are allowed? So we provided a few different options there. Again, pay stubs are allowed. Tax returns are allowed. Those are different options that you have available to you. We do not have participant asked, does your office have a CSFRA compliant lease document template? We do not. You would probably want to speak with an attorney to help draft one. Someone else asks, what is the 2023-2024 AGA? It is 5%, and that AGA applicability period is from September 1st of 2023 through August 31st of 2024. My apologies, that slide had a slight error in it. I will fix it before I send this PowerPoint out to everybody. And then another participant is asking, are we able to use the banked increases from a previous owner? That is a great question. The answer for that, Candace, is no, you are not allowed to use the banked increases from a previous owner. If they weren't used by a previous owner, they are no longer available to the person who's the new owner. Okay, so I'm going to jump into petitions. I'm going to do this at a really high level. If you're interested in filing a petition or learning more, our website has a lot of great information, but you can contact me, and I'm going to give you my contact information in the chat. So you all have it. My email is patricia.black@mountainview.gov, and you can email me with any petition questions. So we're going to go again over this at a very high level. There are really two types of petitions that you as a property owner can file. We have those that are for ensuring a fair or reasonable rate of return. And then we have the joint petition, which is between you and your tenant. Your tenant has to request them, and it's for new or additional housing services, improvements or modifications that are requested by the tenant, and an additional occupant who's neither a replacement roommate or an eligible family member. And then we have tenant petitions. There are 4 types of tenant petitions: unlawful collection of rent, or really 4 reasons, excuse me, I misspoke, 4 reasons that a tenant can file a petition: the unlawful collection of rent, the failure to maintain a habitable premise, a decrease in housing services or maintenance, and an undue tenant hardship cause. We will also be having, starting in the fall, late summer, early fall, a one-time utility adjustment petition. You're going to hear all about this. You will hear from my office. You will hear from me. If you are a property owner who currently utilizes a system like RUBS, or whose tenants pay you for utilities and then you pay the utility provider, and it's separated and it's done in some sort of aggregated, non-specific, not metered way, you will need to utilize this petition process. If you do have sub-meters, or you do already include utilities in rent for all of your tenants, this won't be applicable to you, except that you're going to have to fill out a partial petition and just prove to us, say to us, I already include this in rent, or everything is sub-metered, and just show us that that's the case. You don't have to fill out the whole petition because it won't be applicable to you, but you will have a little bit of a portion of something to do. So again, that one-time utility petition will be happening, and you'll hear from our office a lot of information about it. So I'm not going to go over it very much. I'm not going to go over it at all today, but we will be having a workshop on June 18th that discusses it a little bit more. So does anyone have any? I'm going to go back for a second to property owner petitions. So there are 2 types of landlord petitions. One is for the maintenance of net operating income. So this looks at how much operating income did you make during one time period, adjusted for inflation, compared to our petition year. And if there is a loss there, then you are potentially eligible to increase the rent above the annual general adjustment of rent. This is an involved process, but the outcome is usually in favor of the petitioner. And you work with my office and mostly with me to really go through this process. We go through it together. And then once you've actually completed the petition, and you serve it on your tenants, then it goes into the formal hearing process, which involves a hearing, a public hearing with a hearing officer, and then a decision is made. And if it is found to be in your favor, then the increase can be above the annual general adjustment of rent as outlined in the decision. They're typically successful. We really have, the majority of them have had increases above the annual general adjustment, and it's something that I recommend at least reaching out to our office for if you have questions. The second is for major capital improvements. There's a very simple capital improvement petition that if you have, like, if you're re-roofing your property, if you're replumbing your property, if you're doing big major expenditures, you should consider filing a capital improvement petition with our office. This can even be for those balcony requirements that are coming up from the state. Contact me. Seriously, the capital improvement petition can cover the cost up to a certain percentage of these major capital improvements, and it's an easy process. So please reach out to me for that process. I can walk you through it and see if you qualify, because if you're making big capital improvements, you most likely will. Okay, so before I jump into habitability, I see there's one question. Can you please elaborate on tenant relocation assistance? I will get into tenant relocation assistance, I think, in the next few slides. So we'll go over what habitability looks like, and then we'll be jumping into some of that information. Okay, so habitability. What does it look like? What do you have to do? So as a property owner, you're required to maintain the property in a habitable condition. And this is the state law and the local codes that help define that. There's what we call an implied warranty of habitability, and this is under state law, and it defines certain standards of habitability, what you as a landlord must meet for people to live in your property. And then our local codes, City Code Chapter 25 and CSFRA Section 1706F, provide clarity and detail about those standards. So the landlord has responsibilities and the tenants have responsibilities. Tenants must take reasonable care of rental units and the common area. They must notify the landlord promptly when a problem arises, and a tenant is responsible for damage caused by the tenant or tenant's guests, children, or pets. There are specific rules, regulations, laws around this. So if you're experiencing an issue that you think might be tenant caused, you're going to want to speak with an attorney. And then landlords have specific responsibilities as well. You are required to provide rental units in a habitable condition. And here are some examples of what is included in that. Making sure that the plumbing, the water systems, the piping are working effectively with no leaks, that you're providing adequate gas and plumbing to the property, that the property has electricity and heating, that there are no roofs, holes in the roofs, or holes in the walls, that all of the exterior area is completely sealed off as appropriate, and that there's not water intrusion. You are responsible and required to provide adequate locking doors. There are specific requirements about locks and locking mechanisms, as well as the type of doors that are considered front doors and back doors, external doors. You are also required to make sure that the windows are in adequate working condition. They're not cracked, and that there are window screens. You need to maintain the property so that there's no vermin or mice or bugs, and that the garbage is being picked up and adequately addressed. So again, this is very high level, but these are some things that you're going to want to keep in mind. So what are some recommendations for ensuring habitability? Be sure to perform a walkthrough inspection with the tenant at the beginning and at the end of tenancy, and document the condition of the unit on a checklist and make photos and videos. You can require renter's insurance in leases. It's affordable and it protects against personal property damage. And we also have this great service in Mountain View called the Mountain View Mediation Program. If a tenant landlord dispute occurs, they can help you proactively resolve the dispute at no cost. It's less adversarial than going through the court process, and really helps to improve relationships. So this program has been around for 50 years. It's pretty incredible. And if you have any questions, you can go to mountainview.gov/mediation, or again, contact our office and we can help connect you with the mediation program. They're fantastic. So right to enter. So you're asking yourself, okay, great. The tenant just told me that there's a leak in the bathroom. How can I enter this apartment legally? So here is some information on that. California Civil Code 1954 states that you can only enter the unit for necessary or agreed to repairs or services or allowed inspections. You have to provide 24-hour written notice that states the time, date, and purpose of entry. This is not applicable in cases of emergency like a fire or a flood, and the entry needs to be done during normal business hours. The tenant does not need to be present, but they have the right to be present, and they cannot deny lawful entry, though. Failure to give access after a notice to cease is issued by you, the property owner, can be used as a reason for eviction if the tenant continues to deny access. So now we are at the question of termination of tenancy. So we'll go over what are the just cause reasons for eviction, how do you notice eviction, tenant buyouts, and reasonable accommodations. Okay, so in Mountain View, as I mentioned, there are 9 reasons to end a tenancy. They are kind of bucketed into tenant-caused reasons and landlord-caused reasons. So the tenant-caused reasons are failure to pay rent, a breach of lease, nuisance, criminal activity, or failure to give access to the unit. For those 4 that you see the asterisk there, for breach of lease, nuisance, criminal activity, and failure to give access, you need to provide a notice to cease before giving a notice of termination. You also need to always file any kind of termination notice with our office at mvrent.mountainview.gov. Now, there's also landlord-caused reasons for removing a tenant, and these ones come with the potential access to tenant relocation assistance and the first right of return. So repairs or temporary vacancies lasting longer than 30 days, owner move-ins, the withdrawal of the unit from the rental market, or demolition of the unit. So what does the eviction process look like? You provide a notice to the tenant and a termination notice to the tenant in writing, and a copy of that to us at mvrent.mountainview.gov. Then an unlawful detainer is served. If the tenant has a time period to answer the eviction notice, if that's not done, then it immediately goes to judgment. If the tenant does answer the termination notice, the unlawful detainer, then it goes to court, then there's a judgment, and then the sheriff provides notice. So again, if it's not answered, it goes right to the judgment phase, and there's a request for default judgment. And then the sheriff notices the termination and provides the eviction. And as a reminder, constructive evictions are not and are never allowed. What does a constructive eviction look like? Changing the locks, cutting off utilities, harassing the occupants, preventing occupants from entering, or not addressing habitability issues. These are reasons for tenants to take you to court, and they are illegal. So noticing, how do you notice a termination, especially those based on those landlord-caused reasons? That we see the repairs for our temporary vacancies due to repairs that last longer than 30 days, owner move-ins, withdrawal from rental market, and demolition. So for those, there are certain noticing requirements. So notices of terminations, you have a 3-day notice to pay rent or quit. There's 30-day notices, 60-day notices, 120-day notices, or a year notice. And these all have different requirements based on why you're removing the tenant. So with some of those ones that are landlord caused, you have to follow specific laws on noticing, and they change for the type of notice that you're giving. So you're going to want to contact our office and work with us so that we can help make sure that you're giving the right amount of noticing. There's also time periods and different types of noticing that go into the process if you're withdrawing the rental unit from the market or demolishing the rental unit. You have to provide a notice of intent, which you see down here, which is notice of intent to withdraw the rental units from market to the tenants, and that provides another type of time frame. So again, you need to contact us so we can work with you. And then if you're giving a notice to cease before the termination notice, you have to provide this to allow the tenant an opportunity to cure those violations that we talked about. And you have to provide them with our contact information, this phone number that you see here. So what are the noticing timelines? If you're providing a 3-day notice to pay, rent, or quit, it's just that, a 3-day notice to pay, rent, or quit. That one does not require a notice to cease. If the tenant has rented the unit for less than a year, you provide a 30-day notice. If the tenant has rented the unit for more than a year, it has to be a 60-day notice. And if it's 120 days, it's 120 days in the case of withdrawing the rental unit from the market, and a year of notice if withdrawing the rental unit from the market and the tenant is senior or disabled. Also, I want to mention that not having a tenant who refuses to sign a new lease is not a reason to remove a tenant from their unit. The unit lease then the lease terms that were in effect remain in effect, and the unit goes month to month for them. They can provide you a 30-day notice, but you cannot provide them a 30-day notice. They can stay in the unit for as long as they want until they provide you with a 30-day notice. So again, not signing a new lease is not a reason for eviction. You can still raise the rent as long as you're doing so while in compliance with the law. They remain in the unit. You cannot provide a 30-day notice to them for them not being interested in signing a new lease. They just stay in the unit. Okay, so effective as of September 1st of 2019, this affects noticing and UD terminations. In the countdown of how long tenants have to respond to notice, it now excludes weekends and holidays in calculating response times for non-payment and breach of lease notices and responses for UD laws. So for example, lawsuits. So for example, if you give a 3-day notice on Friday, the rent is due on Wednesday. If you give a 5-day, if you give a UD, the tenant has 5 days to respond. So in the case that it's served on Friday, the response is due Friday. All right, I see I have one question. Are we allowed to charge a month-to-month rate? You can, as long as that increase in that rate is no more than what the allowed annual general adjustment of rent is. So you can offer a lower increase to a tenant who's willing to sign a 12-month lease renewal. And, like, let's say you want to do 2.5% of the AGA for that time period. If you have a tenant who then does not want to sign the lease, then you can offer it, 5 right now, because the AGA is 5%, you could offer them a 5% increase. So you can do that, but that's you have to stay within the bounds of the law. Okay, tenant buyouts. So a tenant buyout is any agreement where a landlord pays a tenant money or other consideration, including but not limited to a waiver of rent in exchange for the tenant leaving. There are a bunch of requirements here, and if you are considering a tenant buyout, you need to contact us kind of immediately. So you have to provide a disclosure form that has to be signed by the tenant before negotiating an agreement. The tenant also has a right to refuse the agreement. And the agreement needs to include considerations, date to vacate, and disclosure. You also need to provide us with the disclosure form and the content of agreement through mvrent.mountainview.com. And the tenant has 10 days, within 10 days after signing an agreement, to rescind the offer. So they don't have to accept it. And if they sign it, they have 10 days to say, actually, I'm not going to do this. So post-tenancy, security deposits and tenant relocation assistance. So for security deposits, You can deduct from the security deposit any unpaid rent, damages to the property, and cleaning. However, there are things that you know, are normal wear and tear that cannot be deducted. So you're definitely going to want to find the details out about security deposits. And if you have really detailed questions about security deposits, Project Sentinel is a great resource for that. So the process, you're going to do an initial inspection 14 days before move out or earlier. And then the move out occurs, you have your final inspection, and then this is a state law requirement within 21 days after moving out, the return deposit. The deposit must be returned with an itemized list of deductions. So just keep that in mind that you're following the law there. Okay, now here's the information on tenant relocation assistance that was asked about earlier. This really ties into those types of evictions, those just cause evictions provided by caused by landlords because they need to do something to their unit or they want to withdraw the unit from the market. So the reasons for termination that trigger relocation assistance and first right of return, again, are necessary repairs that take longer than 30 days, owner move-in, withdrawing the rental unit from the market, or demolishing the rental unit. So this triggers relocation assistance and the first right of return. It also triggers potentially state law SB 330, which you don't have to remember all of these things. We will help you with all of this. If you are in a situation where you're thinking about withdrawing your units, please contact us. We can help walk you through the details of this. So what happens if a tenant qualifies? So tenants have to qualify for relocation assistance, and if they do, then their security deposit is refunded in full. They receive a 60-day subscription to a relocation agent. They receive 3 months rent for a unit of similar size, and there is an increase in that amount for special circumstances, like if there are people over the age of 62 living in the unit, under the age of 18, or people that are disabled. Again, you would contact us and we will assist you and walk you through all of these details. And this is information that's also available on our website. And then I'm sure you're asking what the first right of return means. So if you remove your units from the market and then you decide, oh, wait, I want to bring those back, I want to put them back onto the market, or if you demo your units and then replace them, SB 330 also triggers the first right of return. So this is the state law. If you replace them, you have to replace them with, there are replacement requirements that require you to rent them at a certain amount, or if it's ownership units, provide them at a certain amount of a certain percentage of the area median income. And you have to offer them to the people who had been living in them previously. So if the same rental unit is returned to market, or if the replacement unit occurs and it's triggered by SB 330 or the CSFRA, you have to offer it back to those original tenants. The tenant has to tell you that they were interested in this and provide you with their forwarding address when they leave the unit. And then you are obligated as the property owner to tell us and the tenant that the unit is being re-rented or being, if it's now an ownership-based unit, being brought to market. And there's a whole bunch of rules around that. Again, and this isn't anything you need to remember all the details of, because you'd be working really closely with our department and building in this case. So what is the first right of return? So the tenant has a right to be offered the unit or the new ownership unit for a 10-year period once the unit is brought back to market. And it kind of, you think of it this way, the bottom row there where it says the period of first right of return, that is the 10-year main thing to think about. And then it kind of, the requirements and coverage of the law become less as those years go on. So for the first 2 years, there's a period of vacancy control where the tenant can move back into the unit that was removed from market at the price they were paying plus any applicable annual general adjustments. And they could take you to court for actual and exemplary damages. In units 3 through 5, the period of vacancy control is in effect. So the rent would be reset to what they were paying plus any applicable AGAs, and the tenant could seek punitive damages if you failed to notify the tenant that the unit was coming back on the market. And they have the first right of return always up until year 10. Okay, I see one question. Where is the CSA FRA information in today's presentation found online? So we have a whole bunch of information on our website at mountainview.gov/rent stabilization. And that will start going into all of the details. It's a lot more detailed than this presentation is, and will give you a lot of information. Good question. And that actually leads us into our next section, which are resources. So here's some basic information for you. We have our phone number here, email. You can email us at mvrent@mountainview.gov, and our website that I just mentioned. Our staff speaks Spanish, and we can always get interpretation in just about any language. So if you need assistance in Mandarin or Russian or Turkish, we can get you that. We also have open office hours every Tuesday through Zoom. These are virtual office hours from 10 a.m. to 12 p.m. And you can register for those by going to mountainview.gov/RSP office hours. We also have a housing help center for landlords. And I apologize, this slide needs to be updated. I thought I had put in the new ones. At 298 Escuela, which is our office, 298 Escuela. And for landlords, it's from 1 to 3, or you can join virtually by going to mountainview.gov/housing help clinics. There's also mediation in Mountain View. I mentioned this. This is a great resource, and it is free and confidential and highly successful. And then there are some legal resources for you as well. Oh, I did put it in here. Here we go. This is the slide I was looking for. Every first and third Thursday, we have our Housing Help Center for landlords and property owners. You can come on into our office, or you can join virtually at housing help clinics. And we also have one for tenants. So if you have a tenant who needs some information about the law or is having a challenging time paying rent or has questions, you can send them to us. Again, every first and third Thursday. The difference is that this one is for tenants specifically, and it's from 6 to 8 p.m. at our office, or they can join virtually, just like we have that option for property owners by going to mountainview.gov/housing help clinics. And here's our contact information. So I am also going to answer this question, maybe. Say I allow a tenant to sublet while the tenant takes 3 to 4 months vacation abroad. The tenant is now a landlord. How do I have any control of the sublease? So this sounds like a very specific question, and I recommend that you reach out to our office to help with this unique situation. So you can go ahead and email us at mvrent@mountainview.gov, and we can get you some specific answers. All righty. So that is our very high level, what do you really very much need to know if you're a new property owner presentation. If you'd like to ask any questions, we have a few more minutes before our hour is up. Are there any other questions out there that I can answer for you today? Just go ahead and use the Q&A function or raise your hand. I'd be happy to take some live questions. All right, we have one person here. I'm going to go ahead and allow you to talk, and then you're going to need to unmute yourself there, Mike.
Thank you, Patricia. This has been very helpful.
Oh, good.
So we just inherited a property, and the record keeping was not good And so we are missing leases. All of them are very long-term tenants, um, and on month to month. Um, is there a recommendation or best practices in terms of what we do to redocument these leases when we're kind of flying blind other than what they're paying?
So that's a great question, Mike. You have a couple options. You might want to consider reaching out to an attorney just to help you figure out the estate and all of the complications that arise when you inherit property. That would definitely be a good place to start. There are also, resources available through the California Apartment Association to help with just general language leases. So
Mhm.
they have basically like lease templates that are pretty good to help just kind of get you some lease, a new document at least. Again, your tenants don't have to sign it, but that also doesn't mean that you're barred from offering it. You can definitely offer and just, explain to them exactly what you just explained to me. The thing to keep in mind though, Mike, and I'm happy to speak with you offline and just chat through some of the different things that you might want to consider, is that you can't like reduce housing services and have them keep paying the same amount of rent because of the way the CSFRA works. So you want to make sure that they're still receiving the same level of services, the same level of maintenance on the property, the same, if there was a pool, the pool remains, all of that kind of stuff as you transition. And one other thing to consider is that you're likely going to have an increased property tax situation.
Yeah,
Um,
tremendous.
yeah, so um, I would highly recommend that you reach back out to me. Specifically, I put my information in the Q&A, or in the chat, excuse me. I sent it to everybody already. My email is patricia.black@mountainview.gov. And we can discuss an MNOI petition to help cover some of those property tax bills.
Right.
Yeah, I just worked with another property who's going through the same thing. And I think that I want to impress the importance of it because it's going to make a big difference for your ability to retain the property.
Yes. Thank you very much.
Of course, I'm always here to help and more than happy to answer any questions. So feel free to reach out to me specifically, okay?
Will do. Thank you.
And I have another question. Yes, please go ahead with a specific question here about eviction help and 3-day notices. Please send me an email. Again, my email address is Patricia, PATRICIA.black, black spelled just like the color, at mountainview.gov. Okay. And if there aren't any additional questions today, we are going to go ahead and wrap up. So I'm going to update a couple of these slides that I noticed were a little bit out of date, and then send everyone an email tomorrow with these slides, a PowerPoint of these slides, and a link to a recording of this presentation, as well as the California Tenant Landlord Handbook. So hopefully this was helpful, and we'll be back next month. We're going to have, again, good in-depth workshop on the utility changes that are coming up. So hopefully I'll see everyone then, and I hope you have a lovely afternoon. Thank you so much for joining.